Good afternoon. I'm Kalpna Bharti, Assistant Professor, IIMT College of Law. And today we will discuss a very important topic, that is interpretation of statute. So, first of all, we have to understand the general rule of interpretation. For that, we have to understand what is the meaning of interpretation. So, interpretation is the action of explaining the meaning of something. So when you explain meaning of words in a provision or a law, then we can say that it is the interpretation of law. So it is not a function of law, but a function of language. So deciphering the plain meaning means what the word says, and deciphering the intent, that is subjective in nature, what the word means. So Francis Bennion said that it is, as so often in the linguistic field, a question of feel. A reader may interpret anything from a single verb to an entire verb act. One construe a sentence or longer passage, but not a word by itself. Interpretation perhaps connotes more than construction does, the idea of determining the legal effect. So, construction is more concerned with extracting a grammatical meaning, but interpretation goes behind the giving those words grammatic meaning and giving other meaning to those words. Justice G.P. Singh said, interpretation is the method by which true sense of word or meaning is understood. So, and Solomon also said that the process by which court seeks to ascertain the meaning of legislature through the medium of authoritative form in which it is expressed. So, there are different types of rules of interpretation. First is literal construction, or which is a dynamic concept of interpretation or construction. So in this, the phrases and sentence of a statute are interpreted according to the ordinary and popular meaning, and also the grammatical meaning of those words. The basic and preferred rule of interpretation, unless such a construction leads to an absurdity or content or object of the statute suggests a different meaning. So it is widely used rule of interpretation in taxing statutes. In a case CIT versus TV Sundaram Iyengar, 1975, it was observed that if the language of the statute is clear and unambiguous, and if two interpretations are not reasonably possible, it would be wrong to discard the plain meaning of the word used in order to meet a possible justice. So, the thumb rule of interpretation or literal construction, there are a number of cases. For example, in CC versus Bhalla Enterprises 2004, it was observed that the basic rule of interpretation of a statutory provision is that the plain words of the statute must be given effect. In another case, Tata Iron and Steel Company Limited versus Union of India, it was observed that the rule of interpretation of a document is to given a literal construction. Other rule of interpretation are attracted only when the literal construction does not bring out the idea correctly, fully, and there is some ambiguity left in it. In giving a literal construction, there is no ambiguity. I don't think why it should not be given a literal construction. So, judges in Tata Iron Steel Company, it was held that if we can give a literal meaning to those, we must give it literal meaning only. And in another case, like Commissioner versus Doiba Steel Rolling Mills, in this case also, court observed that the principle that a taxing statute should be strictly construed is well settled. It is equally tried that intention of the legislature is primarily to be gathered from the words used in the statute. Once it is shown that an assessee falls within the letter of the law, he must be taxed, however great the hardship may appear to the judicial minds. The other rule of interpretation are golden rule of interpretation, and it is also known as purposive construction. So it is alternative principles to the literal rule. It applies in case where literal construction of the taxing statute is likely to lead to a manifest absurdity. Means if those words cannot be given a literal interpretation, or if literal meaning given to those words, it can lead to absurdity, then we should apply the golden rule of interpretation, provided that the meaning of the word should be so affected that such absurdity is avoided and legislative intention is given effect. In a case Periyar versus Peri Kani Rubber Limited versus State of Kerala, it was held that it is impossible for the legislature to envisage all situations. Recourse to statutory interpretation therefore should be done in such a manner as to give effect to an object and purport thereof. Doctrine of purposive construction should for the said purpose be taken recourse to. In another case, like Tata Consultancy Service versus State of Andhra Pradesh, it was held that or observed by the court that it is now a well settled law that when an expression is capable of more than one meaning, the court would attempt to resolve that ambiguity in a manner consistent with the purpose of the provision and with regard to consequence of the alternative construction. In another case, like for example, in Inland Revenue Commissioner versus Trustee of Sir John Ard Settlement, it is stated that two methods of statutory interpretation at time been adopted by the court. One, sometimes called literalist, and is to make meticulous examination of precise word use. The other, sometimes called purposive, is to consider the object of the relevant provisions in the light of other provisions of the Act. The general intendment of the provisions. They are not mutually exclusive and both have their part to play even in interpretation of text and statute. In another case, another rule of interpretation, that is mischief rule, and it is also known as Hayden's rule. Uh, it applies for those cases where legislatures carry a particular background or context. Rule stipulated that law be interpreted taking note of the mischief or anomaly should be addressed by it. So it is alternative to literal interpretation and the golden rule of interpretation. According to it, when there is a mischief or anomaly in the law, we must apply mischief rule of interpretation. So it requires examination of some ingredient, like for example, what was the prior law to the enactment of the statute? What was the defect or mischief which the law failed to rectify, and what remedy the legislature provided by law of the statute enacted? What was the legislative intent behind such remedy? So we have to examine these ingredients before applying this mischief rule of interpretation. In England, Inji Industry Service versus Union of India 2004, court observed that when the material words in a statute are capable of bearing two or more consideration, the most firmly established rule for construction of words is the rule of Hayden's case, which was now attained the statute of classic described by the Supreme Court in the case of Kanhaiyalal Sur versus Paramniti Sadhu Khan. There are other examples of these rules, like Edgerton versus Rayon case, where it was held that rule in Hayden's case, which is also known as purposive construction or mischief rule, enable consideration of four matter in construing an act. As we have already discussed those four matters, like what was the law before the making, what was the mischief and defect it wanted to remove, and what is the remedy of the act, and what is the reason of the remedy. So these are the consideration we have to take before applying the mischief rule of interpretation. The other rule of interpretation is rule of harmonious construction. So it applies to reconcile different provisions. As law, general rule of interpretation is that every word of the statute should be given meaning. And so, if one provision or one some words of the provision not giving proper meaning of the statute, we have to apply some interpretation. So if two or more interpretation rule are not possible, we have to reconcile between the different provisions. So in CTU versus Benani Cement Limited, this rule of harmonious construction was discussed, and it was held that generally the principle has four vast application in case of being two statute, general or specific. So this rule of harmonious construction apply mainly in when there is general or specific laws on a particular topic. So a general or specific with letter treating the common subject more specifically or minorly than the former. Uh, the corpus juris stantandem said that when construing a general or specific statute pertaining to the same topic, it is necessary to consider statutes as consistent with one another, and such statute therefore should be harmonized, if possible, with the objective of giving effect to consistent legislative policy. On the other hand, there is where a general statute and a specific statute relating to the same subject matter cannot be reconciled, the specific statute ordinarily will control. So, if harmony between its general statute and its specific statute is possible, we have to harmonize between both of them. But if it is not possible, then the specific statute will prevail. So, in another case of Kamrup Industry Gas Limited versus Commissioner 2004, the court held that the provision of one section of the statute cannot be used to defeat the another unless it is impossible to effect reconciliation between them. Thus, a construction that reduces one of the provisions to a useless lumber or dead letter is not harmonized construction. To harmonize is not to destroy. So, the main crux of this rule of interpretation, that is harmonious construction, is that we have to give meaning to every word, and uh, to harmonize does not mean to destroy. So if uh, without destroying one word we can give meaning to both of the statute or provision or law or words, we have to give it meaning. There are other doctrines of interpretation. One is doctrine of ejusdem generis. In this doctrine, uh, it is given it give meaning to general word, and when it is but when the neighbor words are present with it. So general word contained in the statute may be construed with reference to the antecedent matters, and construction may be narrowed down by treating them as applying to the things of the same kind as those previously mentioned. So if words are previously mentioned and were given meaning, the same kind of words can be given meaning according to those words. So CCE versus Maharashtra Fur Fabric Limited 2002, it was held that a careful reading of two provisions to the notification would show that by resorting not only to process of bleaching, dyeing. So this is the example of this doctrine of ejusdem generis. If some words are given in a statute like bleaching, dyeing, printing, shrinking, tentering, heat setting, crease resistance processing, but also any other process, any two or more of these process, the respondent would lose the benefit of the exemption. It is well settled principle that general term following particular expression take the color and meaning as that of the preceding expressions, applying the principle of ejusdem generis. Therefore, in construing words or when we construe the word or any other process, so we have to import the specific expression, है ना? Will have to be kept in mind. It follows that the word or any other process would have to be understood in the same sense in which the process, including tentering, would be understood. Thus, understood a process akin to centering, tentering would fall within the meaning for the proviso, and consequently, the benefit of notification cannot be availed by the respondent. Another rule of or another doctrine of interpretation is doctrine of nocister societas. So, when words should be known from its accompanying words, we apply doctrine of nocister associates. It was explained in number of cases, like for example, Oswald agro case. It was where it was observed that there is no quarrel with the proposition that in ascertaining the meaning of the word or clause or sentence in the statute, in its interpretation, everything which is logically relevant should be admissible. It is no doubt true that doctrine of nocister associates, meaning thereby that it is the legitimate rule of construction or construe words in an act of parliament with reference to word founded immediate connection with it. For example, when two or more words which are susceptible of analogous meaning are clubbed together, they are understood to be used in a cognate sense. They take, as it were, their color from each other. The meaning of more general is restricted to a sense analogous to less general. This doctrine was accepted by this court in Kachanov cases, but its application is to be made in the to the context and setting in which words came to be used or associated in the statute. So this doctrine of interpretation also observed in a number of cases. The other example is Carthos International case, in which it was observed that the no sister society, meaning that when two words are capable of being analogously defined, then they take color from each other. So the rule of egistum generis is facet of non-sister society rule. The aforesaid principle meaning that general words following specific words would take color from specific. The other rule we can understand in interpretation of the statute is expressive unis est exclusive alt. This rule has given a number of meaning to the statute and was used in number of cases, like uh, in GVK Industry Limited case. So, in this case, it is the territory of India that is specified by the phrase for the whole or any part territory of India. So, in this case, the interpretation of these words, like for the whole or any part or territory of India, uh, the application of this doctrine expressive unis est exclusive alturius was done in this case. The expression, the meaning of this doctrine is the express mention of one thing implies the exclusion of another. When in this case, Parliament has been granted power to make law for a specific territory, and that is India or any part thereof. By implication, one may not read that Parliament has been granted power to make law for territory beyond India. So, conclusion of all this rule or interpretation is that every word should have been given some meaning, or we can say meaning should be given to every word. In Bansal Wire Industry case 2011, it was observed that it is the settled principle of law that the words used in section, rule, or notification should not be rendered redundant and should be given effect to. This is one of the cardinal principle of interpretation of the statute, that some meaning must be given to words used in the sections. So we cannot left some word or leave some word in a statute without giving meaning to those words. We have to give some meaning. by applying literal construction or mischief rule or harmonious construction. It depends on the situation and the type of statute. So these all are the rules of interpretation. I hope you have understand the basic rule of those interpretation. Thank you so much.